Hello friends, welcome to Abhi Law, where law is simplified. This is your Professor Dr. Ambarish R. Patnigire, and in our lecture series of the Code of Criminal Procedure Code, last time we had completed chapter 13. Chapter 13 spoke about the jurisdiction of the court. Now, in chapter 12, the police report was finalized, police challan was submitted in the court. Which court to be submitted? Chapter 13 discussed. Now, after the report has been submitted by the police under section 173, in the proper court, the court which has a jurisdiction to try that offence, then chapter 14 comes into picture. Condition requisite for initiation of proceeding. And in this video lecture, we are going to just get an introduction of this chapter. In this chapter, important word is what is cognizance? What is meant by taking cognizance? Which are cognizable offences? Can cognizance be taken twice? When a magistrate can take a cognizance? Power of magistrate to take a cognizance? Suits against government servant? These are the various questions which we are going to deal in this chapter. These are very important questions as per university is concerned. Now, what is cognizance? Cognizance is nothing but noticing something, considering something. A judicial notice is taken by a court in dealing with a cause. That is called cognizance. What is meant by taking cognizance? To take notice of and consider something, especially when judging. That is taking cognizance. Now, what are cognizable offences? You should remember in the definition section, section 2C talks about cognizable offences, cognizable cases. Cognizable offences are generally heinous or serious in nature, such as murder, rape, kidnapping, theft, dowry, death, etc. The FIR is registered only in cognizable offences. We should remember under section 154. Can cognizance be taken twice? No, it is not permissible. If any such incidents, it might have been done either by mistake or the two incidents might have been different through similar and between the same parties, it can be challenged before the High Court. That means cognizance cannot be taken twice. What a cognizance of an offence is said to be taken? Means cognizance is taken when the magistrate applies his judicial mind to the fact mentioned in the complaint or to the police report or upon an information received from any person regarding an offence. The issuance of process by the court occurs at a subsequent stage duly after considering the materials placed before it. Now, next question will go, what is meant by taking cognizance? Taking cognizance does not involve any formal action by the judge or magistrate, because as soon as a magistrate applies his mind to the suspected commission of an offence for the purpose of taking subsequent steps under the Criminal Procedure Code, for example, summoning of any accused on the basis of the information, this is what basically means taking cognizance. Now, limits to take the cognizance of offence. It is well established fact that the power vested on magistrate to take cognizance of an offence is not an absolute power. It is subjected to limitation. This limitation is discussed in chapter 34, section 467 to 473. Non-applicability of this chapter. The provision of this chapter is not applicable in the case of certain economic offences. Which chapter we are talking about? 34th chapter. Please remember, not chapter 14. And let's understand the difference between chapter 12 and chapter 14 of CrPC. Chapter 12 talks about pre-cognizance stage, means the court has still have to take cognizance of the offence. What is cognizance? The court has still not applied the judicial mind. Once the court notices and applies the judicial mind, that means court has taken cognizance. Chapter 12 talks about pre-cognizance stage. Chapter 14 is the post-cognizance stage. Magistrate has following powers when he receives the police report. Number 1, take cognizance under section 190 at once if he disagrees with the police. Have an inquiry under section 200, reject the report and direct to take subsequent action under section 203, take cognizance of the same offence on the basis of the complaint and the witnesses present under section 200. I hope so you have understood this chapter 14. Okay, this was an only introduction part of chapter 14. For detailed video, we will watch very soon. If you have liked my video, please give a like, subscribe Abhila. Your subscription is our motivation. Don't forget to press bell icon. Remember to share with others. Thank you so much.